Neil Katyal is the former acting U.S. Solicitor General. Andrew Weissmann is the former general counsel at the FBI and a senior member of special counsel Robert Mueller's team. And Lisa Rubin is an MSNBC legal correspondent. This is like a trove of legal brains here. So, Neil, I want to start with you. I mean, you've argued more cases. I've almost lost track. We said in front of the Supreme Court. You were in the court on Thursday. What was your biggest takeaway from listening to the questioning and the back and forth then?
Yeah, you know, Jen, I've seen over 400 arguments there, and most of the times when you walk out of the Supreme Court, you know what's going to happen. And that was not true here. It was very hard to predict where the justices will wind up. And that itself is my biggest takeaway. This should have been an easy case. As you said, Jen, at the beginning of the show, Trump's lawyer was making bonkers arguments. And by contrast, the lawyer for Jack Smith, Michael Dreeben, was very erudite and scholarly and collegial. And I think if you weren't in the courtroom, it sounded very much like just a scholarly disquisition, and it wasn't really persuasion. In the courtroom, I think that Michael Dreeben made a lot of points that did land with the justices. And I think the most chilling point came with it was at 11:55 a.m., almost 2 hours after the argument began. Dreeben had been talking for more than an hour, and he described to the justices something that you were saying. This is not hypothetical. Here's what this indictment says Donald Trump did to the Justice Department, pressuring the Justice Department to try and send letters to state legislatures saying those election fraud and the like, and then threatening to fire those DOJ staffers when they refused to do that. And the justices did really perk up there. So I saw 4 justices, Justices Sotomayor, Kagan, Jackson, and also Justice Barrett, I think, really rejecting this absolute immunity claim. And the question is, where is the Chief Justice on this? He was playing his cards close to the vest.
Yeah, such an interesting piece. Andrew, let me turn this question to you. I mean, did anything surprise you, and what did you make of any tea leaves on the Chief Justice?
Well, I think that it's important to remember that at the outset, the court had already given Donald Trump the win that he was seeking, which is the delay of the D.C. trial. So going into this was all upside for him. I mean, I think he had to be thinking, I'm making this really outlandish argument with ramifications that couldn't possibly be squared with the text and history, the text of the Constitution or the history of the presidency. So it's all upside if the court would actually bite on this. And so what was surprising is that there were justices who actually were taking this seriously. And it just was frankly shocking. Remember, going into this, the given was that private conduct was certainly not immunized from criminal liability. And but what everyone's talking about now is, hey, maybe they'll think that some of this is private and they can go forward. But that was what was a given going into this. And the reason people are thinking that is because there seem to be 4 justices who are really taking Donald Trump's claim of criminal immunity seriously. And we are, I mean, I know it sounds like hyperbole, but I think your opening is so correct that we are essentially, as Neil put it, one vote away from sort of the end of democracy as we know it, with checks and balances. And to say it's an imperial presidency that would be created is frankly saying it would be a king. He would be criminally immune. And that is what is so shocking, is how close we are. And we are really on the razor's edge of that kind of result, but for the Chief Justice.
Yeah, I mean, one vote away. When you put it in those terms, Andrew, it is very, very stark. Lisa, I wanted to ask you, and Andrew sort of referenced this, I think, if I was hearing him correctly. I mean, Amy Coney Barrett had a kind of line of questioning that jumped out to me. I'm not a lawyer, though, where she was basically pinning Trump's lawyer down on the distinction between official and private acts. I mean, did that stick out to you? And what are they trying to get at? What is she trying to get at there in your assessment?
I think she's trying to get at the fact that the indictment mostly alleges a number of things that are private acts, that despite the characterization of John Sauer as many of the acts alleged in the indictment as official, that actually they're anything but. In fact, at one point, the president advanced a defense on the basis of the First Amendment. And those two things can't coexist. You can't say on one hand that he's been charged with what are primarily official acts, and on the other hand, claim First Amendment protection, because the First Amendment would not apply to the president but for the fact that he's acting in a personal or campaign capacity. So I think Amy Coney Barrett trying to suss out and pin down John Sauer with respect to the actual allegations in this indictment were both helpful and surprising, because no one had Amy Coney Barrett necessarily on their bingo card as the swing vote here.
Yeah, and I certainly didn't, and it sounds like most of you didn't either. Neil, I want to play a moment from Justice Alito during these arguments. Let's play that, and I want to talk to you about it on the other side.
If an incumbent who loses a very close, hotly contested election knows that a real possibility after leaving office is not that the president is going to be able to go off into a peaceful retirement, but that the president may be criminally prosecuted by a bitter political opponent, will that not lead us into a cycle that destabilizes the functioning of our country as a democracy?
I mean, he seems to be arguing in plain English that immunity is necessary because otherwise presidents will fear prosecution and be therefore incentivized to attempt to hold onto power unlawfully, if I heard that all correctly. But Neil, what did you make of that statement by Alito?
Yeah, I thought it had missed two really important things. One, the over 200-year history of this country in which that's literally never happened, even though we've always thought that presidents were subject to criminal liability. And second, it ignored the remarks made very powerfully in January 2021 when a lawyer went to the Congress and said, do not impeach President Trump. Instead, you can indict him after he leaves office on January 20th. That person was Donald Trump's own lawyer. So Trump in the impeachment was saying, I can't be impeached, I can only be indicted. Now that he's left office, he's saying, I can't be indicted either, and of course I can't be impeached. So, this is all just a recipe to put him above the law.
He's said a lot of things that come back sometimes to bite. Andrew Weissmann and Lisa Rubin are back with me. Lisa, so much legal news for both of you. Thank you again for being here. Pecker clearly was first for a reason, and you both have been part of the strategy of this. Now, having heard it, how did he lay the groundwork for the prosecutor's case as we look to the next stage?
Brilliantly, I'll say, and that has a lot to do with the homework that the Manhattan DA's office did. But remember, Jen, this case is not so much about the hush money scheme as it is about falsification of business records, 34 counts of it. But what makes it a felony is that it was done to either with the intent of concealing or committing another crime. And what Pecker did was establish that other crime, namely a conspiracy under New York election law to promote or prevent the election of a particular person through unlawful means where one or more acts were taken in that direction. Pecker laid all of that groundwork, the formation of the conspiracy, the unlawful means, meaning the Karen McDougal settlement payment and the way in which it was orchestrated. And then thirdly, the fact that the unlawful means here was not only the agreement, but the fact that they had sort of larded it up with services, an attempt to skirt campaign finance law. In other words, he knew that paying her off to suppress her story with the goal of promoting Trump's election was unlawful. And so what he did was, in that agreement to purchase up her story, also provided that she would do columns for the National Enquirer or serve as red carpet interviewer for Radar Online, one of their properties, and the like. That was all a ruse, although a ruse that Karen McDougal herself took very, very seriously. And that's what posed problems for them eventually, because she wanted them to make good on that portion of the agreement. And really, they had done it all along to silence her.
I mean, the Pecker testimony was so interesting. A lot of it was, I can't believe this all happened this week. I wanted to just go in reverse before Pecker, Andrew, and ask you about Todd Blanche's opening statement. This all happened this week because he made some pretty bold statements in their hearing, just even as a non-lawyer. He basically denied Trump's alleged affair with Daniels. That's not a part of the legal argument or necessary in the legal sense, but does that matter? And how could that come back to bite him, or if it could?
So one of the things when you are on trials, when you are either the prosecution or the defense, you need to be extremely careful about what you promise a jury. And what happens is both sides listen very carefully to that, and it will come back. If you have promised something that did not come to play, then you are going to hear that. So the statement that denying the tryst with Stormy Daniels, I mean, I'm not really sure how that is going to come into evidence, because Stormy Daniels, if she testifies, is clearly going to say it happened. Donald Trump, who I think everyone thinks is not going to testify. I mean, I'm sure the prosecution would love it if he did. But for the same reason he never met with us in the Mueller investigation, I think there's no way in God's green earth that he is going to testify. So I don't know how that is going to come into play. As Lawrence O'Donnell has said, you know, that's the kind of thing where it may be that Todd Blanche felt he had to say that for his client, but it is
like
going
the pressure.
Exactly, that he needed to say it for sort of the sort of public consumption, but at trial, it is going to hurt him if he doesn't prove it up, because in summation, you are going to hear the state saying, this is what he told you. That is not true, and the message being that don't trust him. So it's very, very important what people say in openings. Obviously, it remains to see what the jury makes of all of that.
Yeah, of everything that's happening. So, Lisa, one of the things we learned this week, there's text and email exchanges for all of this, some of which we learned about this week. I mean, we learned about a text message that Dylan Howard, the top editor of The Inquirer, sent to a relative on election night saying, quote, "At least if he wins, I'll be pardoned for electoral fraud." I mean, Judge Merchan, if I'm correct here, won't allow it in evidence, but doesn't it make it really clear that they knew this was illegal?
I think it absolutely makes it clear that not only did David Pecker know that it was illegal, but that Dylan Howard had figured that out as well. And Jen, I should say, you know, this is sort of a close call from an evidentiary perspective, because most times statements of a co-conspirator can be admitted into evidence. On the other hand, as Merchan reasoned, this was a statement that he didn't make to another member of the conspiracy, but rather was making to a first-degree relative. And moreover, Dylan Howard is not coming to this trial to testify. He lives in Australia now. David Pecker revealed in his own testimony that he understands that Dylan Howard has some sort of health problem that makes it untenable for him to travel. And so on balance, Judge Merchan decided that this would be too explosive to expose the jury to. But if you read the transcript and the sidebar between the lawyers where they're talking about the text messages from Howard to that first-degree relative, there is more of where that's coming from, a lot of other statements that indicate that Howard fully believed that Karen McDougal was telling the truth on election night, was horrified to see what had gone down. If those statements had come into evidence, I think it would have been one more notch in the DA's belt with respect to proving up the existence of the conspiracy and the understanding on the National Enquirer's part that this was not only wrong, but unlawful.
Okay, it's safe to say, and I'm sure you're tracking this, that there was a lot of legal news this week. In a courtroom in downtown Manhattan, there were hours of testimony about Donald Trump and the National Enquirer and how they worked together to kill stories that might hurt his chances in 2016. Learned a lot about that. Here in Washington, inside the Supreme Court, Trump's lawyers were making the argument that, sure, killing your political rival would be completely fine for a president. That was their argument. I mean, it's been a lot to take in. But what happened this week matters. It should matter to you, all of us. And it's important to talk about why, especially during these moments when it feels like we're all drinking from a news fire hose. So we're going to start on Thursday at the Supreme Court, because when you listen to these arguments, and it's cool that we could, you may have thought to yourself, I mean, this can't possibly be serious.
If the president decides that his rival is a corrupt person and he orders the military or orders someone to assassinate him, is that within his official acts that for which he can get immunity?
It would depend on the hypothetical, but we can see that could well be an official act.
I mean, you heard that correctly. He said it could be an official act. So basically, I'm going to pause here. The lawyers for the former president of the United States and likely Republican nominee are arguing that, sure, if he or any other president for that matter just has a feeling that their opponent is corrupt, they can take care of that by killing them. But wait, there's more. At one point, Justice Kagan asked if a president can sell nuclear secrets to a foreign adversary. What did Trump's lawyer say? Basically, yep. And what about ordering the military to carry out a coup? Can he get away with that? According to Trump's lawyer, maybe. So basically, if a president does it, if he kills, if he coups, if he sells national security secrets, it's not illegal. And look, it may have sounded like the justices, when you listen to this, were preparing this for this hearing by coming up with the absolute craziest possible scenarios. Things so far outside the realm of possibility that whatever shocking thing Trump's lawyer said in response didn't really matter because, no, it's not something that would actually happen here. But the thing is, none of this is that much of a hypothetical when it comes to Donald Trump. I mean, in 2020, he was reportedly involved in efforts to direct the defense secretary to seize voting machines. That sure sounds like trying to use the military to carry out a coup. And just a few months ago, he mused about executing former Joint Chiefs Chairman Mark Milley. Trump once repeatedly said a staffer who leaked a story about him should be executed too. And in an interview on Friday night, just 2 days ago, former Attorney General Bill Barr said he used to say that kind of thing all the time. So when it comes to Donald Trump, no, those hypotheticals that got tossed around the Supreme Court this week aren't really hypotheticals, are they? I mean, this is stuff he talked about, stuff that was clearly rattling around in his head, still is. And this is stuff his lawyers are now saying should be A-OK for a president to do. And here's the other really important thing to understand about all of this. I mean, the view of the presidency that Donald Trump has, very clearly, this absolute power above the law mindset, is literally his plan for a second term. I mean, the plan, there's a plan. Right now, the far-right think tank, the Heritage Foundation, is hard at work drafting plans to convert Trump's calls for revenge and lawlessness into action. It's called Project 2025. It's nearly 1,000 pages long. It's online. You can read it if you want. It's probably not a beach read, but you can take a look. In the meantime, I'm going to give you kind of like a Cliff Notes version of all of this. Their goal in this plan is to, quote, assemble an army of aligned, vetted, trained, and prepared conservatives to go to work on day one to deconstruct the administrative state. One big area under attack, no surprise, the Justice Department, which Project 2025 says has lost its way. And as the New York Times writes, to find its way back, it must become subservient to the White House. In plain English, that all basically means they want to remake the structure and the staffing of the Justice Department so that an independent branch of government looks the other way. Well, Trump basically does whatever the heck he wants. Now, as the New York Times put it, according to the Project 2025 plan, the law must submit to the president's priorities. If not, the lawyers are doing it wrong. So, yeah, I mean, I'll admit it. Oral arguments in the Supreme Court aren't exactly appointment television all the time. They're confusing. They're definitely long-winded at times. But they matter, clearly in the context of this specific case, but also because the responses from the Trump legal team tells a whole lot about how he sees the power of the presidency and how he looks at a potential second term.